Thank you for participating in this fraud awareness briefing. My name is Dan O'Rourke, and I'm the Assistant Inspector General for Investigations for the Office of Inspector General at the Legal Services Corporation. Fraud awareness briefings are offered to provide LSC grantees information on the conditions that can lead to fraud. During this presentation, we will discuss who may commit fraud, how fraud may occur by providing real case examples, and what to do if you suspect fraud. Of importance, we will offer best practices to prevent fraud schemes that have occurred in previous OIG investigations. We believe that if grantees have knowledge of the various fraud schemes, possess effective leadership, and have the right internal controls in place, fraud can be prevented. Let me summarize the goal of our fraud awareness briefings. An entity-wide fraud awareness training program cuts fraud losses and ensures that payments and related services reach the hands of the people who need them the most. This slide represents our organizational structure. We're led by an Inspector General, Jeffrey Shans, and have three components: audit, management evaluation, and investigations. Within investigations, we employ analysts, investigative counsels, and investigators. We report to Congress and to the LSC Board of Directors. Here's our employee roster for investigations. We have a talented group of individuals. Our goal is to be a resource for grantees. We want to educate and assist grantees so that you do not become a victim of fraud. Here is today's agenda. The role of OIG investigations. We will discuss the fraud triangle. We will provide examples of past fraud cases, and we will offer information on prevention and best practices to avoid fraud in your program. For OIG investigations, we typically have two roles: prevention and detection. On the prevention side, the LSC Board and the Inspector General has emphasized the need to focus on prevention activities with grantees to promote awareness and reduce fraud rather than play the gotcha game. We want to get ahead of the fraud through fraud prevention, and fraud awareness briefings are a terrific way to do that. On the detection side, we do investigations associated with fraud and/or regulatory violations in LSC grantee programs. We can do that through criminal, civil, or administrative means. This slide represents the cost of frauds in LSC programs during the last 10 years through OIG investigations. As we know, there are consequences associated with stealing funds meant for low-income clients. As you can see in this slide, and of note, in the last 10 years, there have been 21 indictments, 15 guilty pleas, and 20 terminations. And also criminal restitution of over $2 million, and question costs and discontinued payments of over $800,000. Who commits fraud in the nonprofit world? Ordinary people who may have a financial pressure in their life, or they may believe they can circumvent the internal controls at your program. Again, it could be an executive director, financial person, or even an intake staff person who has access to the financial stream of the actual program.
My name is Charlie Becker, and I'm a senior investigator, and I'm going to discuss the next 8 slides. The first slide deals with the fraud triangle. The fraud triangle is a model for explaining the factors that cause someone to commit occupational fraud. It consists of 3 components, which together lead to fraudulent behavior. The first component is pressure. This is a perceived financial need. This is what motivates the crime. Pressures can be caused by outstanding debt, sickness, college tuitions, and vices like gambling and addictions. Once we've gotten the pressure, the next step is the perceived opportunity. This is where a person sees some way to abuse their position with a low risk of getting caught. So some of the ways that contribute to this is managers not managing. This is what we would call our bad tone at the top, or not having good financial practices. Many of the programs that we find have frauds do have good financial practices, but for one reason or another, those practices are not followed. And the third part of the triangle, once we've had the pressure and the opportunity, is the rationalization. Many fraudsters are, particularly in LSC funded programs, are first-time offenders with no criminal record, and therefore they try to justify the crime to themselves. They will tell themselves it didn't hurt anyone when really it did. It's only a short-term loan, which hardly ever happens. No one ever pays these things back until they get caught. I deserve it. I didn't get the bonus, I didn't get the promotion, and someone else did, and it was really my promotion to get. And everyone else does it. And even though everyone else does it, it doesn't make it right, and it's still a crime. The following sections of this presentation will consist of case studies. In the case studies, we will be presenting details regarding actual investigations conducted by the Office of Inspector General. The case studies will highlight the program areas affected by the particular fraudulent activity, and the case studies will include those involving accounting fraud, time and attendance fraud, payroll fraud, staff travel and reimbursement fraud, revenue stream fraud, credit card fraud and abuse, outside practice, employment and client diversion, question cost, regulatory violations, and conflicts of interest. In the following slide, I will discuss two cases involving accounting fraud. The first case involves Benny's missing goods. Benny was a long-term trusted employee. He was a CFO at a program for 30 years. Benny had several vices. He spent a lot of money on gambling and exotic dancers. Benny created a bogus office supply company. The way it worked was Benny and his friend Sonny, who owned a check cashing business, entered into an agreement to sell office supplies to the grantee under the guise of a blanket agreement. Benny would send purchase orders to Sonny's office supply company. Benny would prepare the bogus supply company invoice and had Sonny deliver the invoice to the grantee for payment. And the person he delivered it to, of course, was Benny. Benny approved the invoice and issued a check to Sonny's office supply company. At times, as much as $120,000 in supplies were bought at one time, of which $12,000 was used to actually buy supplies. Benny and Sonny would split the leftovers, usually 90 cents out of every dollar, 75 cents to Benny and 15 cents to Sonny. Benny got the most because it was his idea. With the remaining 10% of the funds, Sonny would buy supplies as needed by the grantee from a known office supply retailer that delivered the supplies to the grantee's offices. Benny then would verify receipt of the supplies as if the program had received 100% of the order, not just 10%. Benny retired, and the fraud was discovered after his retirement, partially because Sonny inquired as to who would be replacing Benny in conducting the scheme. The moral of this story is if you have a partner in crime, maybe you should try to pick someone who's more intelligent than Sonny was. Benny conducted this fraud for over 10 years. He was prosecuted for stealing $1.2 million of LSC funds in 5 years. He stole another 1.2 in the 5 previous years. However, he was not prosecuted for this because of the statute of limitations. Benny was sentenced to 30 months in prison, and Sonny was sentenced to 15 months in prison. The next case is Sherry's Wanderlust. If you haven't realized by now, if you steal money from an LSC-funded program and you get convicted, you get a slide named after you. Sherry was also a long-term trusted employee and family friend of the executive director. She also had financial problems. She had a $100,000 IRS lien placed against her, and she had some gambling problems. She started her fraud by writing fraudulent program checks to herself. She would enter the name of a legitimate vendor in the program's accounting system, but instead of printing the check to the vendor, she would write the check to herself. This went undetected because Sherry would receive the bank statements and destroy any documentation accompanying the bank statements that would show that the checks had been written to her. She also used the program's credit card at a place called Wanda's Bargain Basement. Wanda's was a tobacco, alcohol, and video poker establishment. Sherry would go to Wanda's and get a $300 cash advance on the program's credit card so she could play video poker. This was not enough for her, so the maximum amount of advance she could get in one day was $300, and she needed more. So she, unbeknownst to the executive director, she opened up a debit card on the program's operating account, which allowed her to get an additional $300 cash advance at Wanda's. So on any given day, she would take $600 of the program's fund to play video poker. In addition to this, she set up electronic payments from the program checking account to pay personal credit cards, cable, telephone, and utility bills. She also set up her boyfriend as a program contractor and made fraudulent payments to him when no work was done. Sherry was out of the office when one of the statements arrived and was opened, and this is how her scheme started to unravel. Sherry was responsible for over 500 transactions totaling $195,000 from 2002 to 2008. She was sentenced to 22 months in a federal prison, and when she was sentenced, the judge stated that Sherry not only stole from her program and LSC and the federal government, but from all of the poor people that her program served. The following is a list of some ways that accounting fraud can be prevented. One is by performing monthly bank reconciliations. Second is positive pay. Positive pay is a feature that is offered by many banks. When using this, a program would submit a listing of checks written with payee, amount, and check number to the bank. If all three do not match when the check is negotiated, the bank will not cash the check. The next is separation of duties. In Benny's case, if there would have been a separation of duties, Benny would not have been able to place the order, write the check, and verify that the goods had been received. Reconcile questionable purchases. At any one time, Benny was purchasing $120,000 of supplies. This is not reasonable and probably should have been looked into. Rotate the IPAs. Many programs have had the same IPAs for 20 years. In both Benny and Sherry's cases, the IPAs were deficient in performing their responsibilities. Ensure that sufficient fiscal oversight is maintained by the executive director and the board, and have at least 1 week of consecutive leave for fiscal staff. This allows other staff to understand and perform the duties of the folks that are on leave, and also would have properly prevented the issues that arrive with Benny and Sherry. And also have a strong whistleblower policy. If someone sees something, they should feel comfortable to say something to management regarding a possible problem. Now I'm going to discuss some cases involving payroll fraud. The first payroll fraud case involved identity theft. The payroll clerk knew that certain staff worked on an intermittent basis and that on any given pay period they would claim no hours. She would identify the staff who had not worked any hours, knowing they would not be expecting a paycheck. She changed those employees' direct deposit information to hers in the payroll system and then entered hours worked for those employees. Once the payment was made to the payroll clerk's bank account, she changed the direct deposit information back to the employee's legitimate information. The payroll clerk was arrested in the program's lobby for stealing from her previous employer. When we investigated her activity at the program, we identified approximately $10,000 in fraudulent deposits that had gone into her bank account. She was also arrested for this and prosecuted and convicted. The second case involves padded pay. This is a situation where an individual had complete control over the payroll system with no management oversight. The employee was in a management position and should not have been eligible for overtime. However, she classified herself improperly in order to get overtime. In addition to padding her overtime, she claimed hours that she had not worked and was not even in the office, and she charged numerous overtime hours for time she spent on making payments to payday loans. These are personal payday loans with whom she had debts, and probably should not have been spending her time doing this instead of doing the program's accounting work. The following are some actions that can be taken to help prevent payroll fraud. Ensure that supervisor approval of all timesheets, and make sure that once a supervisor approves the timesheets, they cannot be changed. Require advance approval of hours outside the normal work week. This includes overtime, weekend time, before and after hours, and telework. Require notification to the payroll administrator and to the employee when direct deposit information is changed. In the identity theft case, the program had the opportunity to do this, but they never invoked this option with their payroll provider. Reconcile timesheets to payroll, and also compare work activity, such as calendars, emails, case files, to payroll dates and hours to make sure that they both agree.
Hello, my name is Mike Shiohama, and I will be covering time and attendance fraud and travel fraud. Starting with time and attendance fraud, there are two areas of concern. The first is staff claiming and being paid for hours not worked. And the second, staff not entering their time contemporaneously is required by LSC Reg 1635. Let's talk about a recent case that the OIG had. This case involved being paid for hours not worked and dealt with contemporaneous timekeeping issues. This case involved a subgrantee ED who was paid for hours not worked while taking classes to earn credit towards a graduate degree. The OIG's review of case management entries disclosed that the hours entered by the ED were made 4 to 6 weeks after the date of the fictitious hours that she claimed. A review of the timesheets, case management records, and payroll records disclosed that she claimed 8 hours of work on her timesheet. Her case management entry supported an 8-hour workday, and her payroll records disclosed that she claimed 8 hours as being worked. The case was made by third-party documents that confirmed her attendance as an intern taking classes. This case resulted in her termination. She was ordered to repay the program and was placed on 1 year of supervised probation. Now for the case study. Based on a hotline complaint, the OIG received an allegation that the office manager for a grantee had paid herself over $100,000 supported by false timesheet entries. Our investigation disclosed that she received multiple paychecks for each pay period. For this program, the ED was the only person who could sign the checks, and the office manager was the person that prepared the checks. It should be noted that the ED signed blank checks for the office manager. To support the extra paychecks, the office manager claimed 70 hours of work each week. It was a grantee's accountant that helped make the case. He confessed that he prepared the false timesheet at the office manager's direction. He stated that he and the office manager came in on a weekend to enter the false hours onto her timesheet. And in return, he was able to keep his job and was given a living stipends under the guise of being a victim on a VAWA grant. It should be noted that the ED also received extra paychecks in the amount of $30,000. The case also disclosed that there was no board oversight. During the entire time of the scheme, which was 18 months, there were no board meetings. As a result of the case, the office manager and ED pled guilty in order to make full restitution. The ED was sentenced to 6 months in jail, and the office manager received 9. Here are the recommendations for time and attendance fraud. Instead of reading the list, I would like to add one more recommendation, and that's having good board oversight to reduce the risk of fraud. Simple things like having the board review the ED's timesheet, travel, and expenditures creates transparency and deterrence. And if the board reviews account budgets to actual expenditures, at least in this case, they would have questioned the amount spent on payroll. Now for travel and reimbursement fraud. The OIG investigates more allegations of travel fraud than any other reported fraud issues. Some issues of travel fraud include, first, travel with little or no business purpose for personal benefit. In this example, we had an office manager who took and was reimbursed for travel so that her husband could compete in a sporting event. She was eventually caught for other fraudulent activities and lost her job. Another investigation dealt with an ED padding her travel claims. In this case, the ED claimed and was reimbursed for a $400 meal, which included a $200 bottle of wine. This was one of many false claims. On this case, the ED was eventually charged for theft to grant funds. Now we will discuss the case study for cruising with Leo. Here are some facts from the OIG investigation. Leo was the disbarred attorney and was hired by the grantee as a paralegal to handle VA and SSA benefit cases. Based on interviews, nobody wanted to supervise Leo. So the ED gave Leo a position where he supervised himself. Because of this position, Leo could submit his own travel vouchers to accounting without a supervisor's review or approval as long as he did not claim lodging or per diem. To support his travel claims, Leo opened a case with the client name in the case management system. It was only a data entry to support his claim. There were no case files. For the 336 days that Leo worked, he claimed mileage ranging from 250 to 700 miles round trip each day. On his reimbursement claim, he stated that he started his workday at 5:30 a.m. and returned home at 10 o'clock at night. No per diem or lodging was claimed. Based on a review of third-party documents by the OIG was able to prove that Leo never traveled to destinations as claimed on his travel vouchers. The investigation found that 1. The grantee had a badge entry system, and a review of the entry system records disclosed that Leo had a card swipe to enter the building on business days around noon. 2. The office also had a telephone system that recognized where employees listened to their telephone messages, and based on the system records, Leo listened to his messages at his office desk during business hours. And 3, the best evidence was an analysis of names used by Leo against agency records that disclosed that some client names were individuals that were deceased, or they had no record of the individual, or they had no record of a claim being filed for the individual. This case resulted in Leo pleading guilty, was ordered to pay full restitution, and was sentenced to 54 months incarceration. And now for travel fraud prevention recommendations. Again, instead of reading the list on the screen, I would like to share one more recommendation, and I call it ROI, or return on intake. Based on OIG investigations, there were some cases that involved employees who conducted outreach in the field. Based on our cases, we found very little, if any, intake taken for those events. So you have to ask the question, are you getting the expected intake from your outreach events? To address this problem, there's no problem having the employee add the contact information for each event on the travel plan. If there is no intake or very little intake for the event, or you suspect something is wrong, call the contact and ask, was our visit helpful? If they answer, what visit? There's a problem, and call the OIG. Well, that's it for my part of the presentation. Thank you for listening to my stories.
Hi, my name is Marco Cortina, Investigative Counsel with the LSC OIG. Today, I'll be presenting slides covering the topics of fraud related to grantee revenue streams and credit card fraud. We're going to go into some real-world case studies to help illustrate these areas. So, with respect to grantee revenue streams, we've had past cases involving the theft of grantee court-awarded attorney fees, client payments of fees intended for the client trust account, and donations. So obviously these don't comprise all grantee revenue streams, so we'll touch on other areas a bit later.
Our first case example is Kevin's attorney's fees. Kevin was a managing attorney at a small grantee branch office. Prior to working for the grantee, Kevin worked as an attorney in private practice. Part of his private practice involved court-appointed cases at local county courts, for which he received a fee from the counties. When Kevin was hired by the grantee, he was permitted to work court-appointed cases on behalf of the grantee in counties near his branch office. These cases included child abuse and neglect cases. Within 6 months of being hired, Kevin began taking the attorney fees for the cases he worked on behalf of the grantee for himself. He did not remit the fees to the grantee as required by LSC regulations and grantee policy. In other words, he stole the attorney fees. Kevin had the fees made out to KSL Corporation, an entity he owned and controlled. Over a 3-year period, Kevin received 16 payments from 2 different counties, totaling just under $25,000. Each payment was for a case Kevin worked on behalf of the grantee. So going back to the fraud triangle, Kevin's financial pressure was gambling debt. He had a gambling issue, unfortunately. Kevin saw an opportunity to steal because he realized that no one at the grantee was ensuring that the attorney fees made it back to the program. And the third leg of the triangle, rationalization, I believe Kevin convinced himself he wasn't stealing. He told us that he took the fees. He didn't want to use the word steal. He likely felt that he was entitled to the fees. So what happened to Kevin? He was immediately fired after the theft was discovered. He was disbarred from the practice of law. We worked with the U.S. Attorney's Office to get Kevin indicted in federal court. He pled guilty to 1 count of theft from a federal program, a felony. He was ordered to pay full restitution and sentenced to 12 months in federal prison. Our second case example is called Gabby's Greed. Gabby worked an intake desk for a grantee. Gabby would have clients give her a blank money order or cash for a filing fee related to their cases before U.S. Citizenship and Immigration Services. Typically, these were VAWA cases where Gabby was assisting clients submit employment authorization applications. Gabby would request that the grantee pay the filing fee in her cases, and subsequently, she would apply for a fee waiver from USCIS. Gabby would then pocket or steal the application fee. The total theft in this case was over $50,000. So going back to the fraud triangle, in Gabby's case, sometimes, and this is rare, but sometimes there really isn't much of a financial pressure except for greed. In Gabby's case, when we asked her why she stole the fees, she said it was just too tempting not to take. And similar to Kevin's case, Gabby had the opportunity to steal because the internal controls of the grantee were not catching the theft. So what happened to Gabby? Gabby lost her job immediately. She was ordered to pay full restitution. She was sentenced to 3 months in prison and 8 months of home supervision. Prevention.
With respect to client trust accounts, the OIG issued a fraud alert on this topic, which contains an exhaustive list of best practices. It's on our website. If you're concerned about client fees being stolen, I urge you to check it out. Posting signage in the area where clients provide payments to your program is one of the best practices. That also goes for donations. The signage should state that all payments should be made payable to the grantee and not to staff members or case handlers. Signage could also state that everyone who provides payment to a grantee is entitled to a receipt. Using pre-numbered receipts and receipt books is also a best practice, and discouraging cash payments as well. With respect to attorney fees, managing attorneys should be aware of all fee-eligible cases they supervise, and they should ensure that fee-eligible cases are not closed until the program receives the fee associated with that case. Accounting departments should also be made aware of cases where an attorney fee is expected, and the fee should be treated as a receivable so accounting staff can follow up if a fee isn't received. Now, the cases we touched on today were examples of fraudsters employed at grantees. There are also plenty of individuals outside your organization looking for ways to steal money. Most grantees regularly receive substantial grant payments. Please ensure that all your online accounts, that include savings, checking, operational accounts, investments accounts, are secured. You should restrict access to those who need access to your accounts. You should regularly change passwords, and please make use of two-factor authentication if available. Moving on to credit card fraud. Nearly all grantees use credit cards for purchasing, and most grantees now utilize multiple program cards. Unfortunately, credit cards are vulnerable to theft and misuse. Our credit card fraud case study is called Chris's Cards. Chris was a director of IT at a grantee. He had a grantee credit card issued to him in order to make IT-related purchases. He used the credit card for that purpose, but unfortunately, he also used the credit card to make over 30 personal purchases, non-business related personal purchases. The vast majority of Chris's personal purchases were for sports trading cards. For several of the purchases, Chris fabricated fraudulent invoices to make it appear that the trading card purchases were for legitimate IT expenses, and then submitted those invoices to the grantee accounting department. So, going back to the fraud triangle, financial pressure. Chris had debt. Chris also was a veteran, and he told us that he had difficulty transitioning back to civilian life. As far as opportunity, Chris's credit card statements were not being reviewed regularly by the accounting department. Part of that was an issue with the bank, where the grantee wasn't receiving credit card statements for a time. Also, the fraudulent invoices were reviewed by the accounting department, but were not initially flagged as suspicious. So what happened to Chris? We worked with the U.S. Attorney's Office, and Chris got federally indicted. He pled guilty to 1 count of theft of public money. He was ordered to pay full restitution and sentenced to 24 months of probation. Credit card fraud prevention. We recommend prior approval of all credit card expenditures. We understand that at some programs, the volume of credit card purchases makes it difficult for each credit card transaction to be pre-approved, but we still recommend this as a best practice. If every credit card transaction cannot receive prior approval, we recommend that you at a minimum establish policies outlining prior approval thresholds. For example, all credit card charges over $50 must receive prior approval from a manager, executive director, or supervisor. All executive director purchases should be reviewed by the board. Some programs have established policies where the board pre-approves purchases. Other boards review ED purchases quarterly or after a comparable period of time. Of course, every transaction needs to have an itemized receipt. For IT purchases, we recommend that the purchase approver have some background or knowledge of IT. We recommend that you establish clear credit card usage policies, including a credit card usage acknowledgement form to be signed by all credit card users. The form should make it clear that using a program credit card is a privilege, and misuse of a credit card can result in suspension of credit card privileges, termination of credit card privileges, and termination from employment in the worst cases.
Hello, my name is Jen Sheldon, Investigative Counsel. I'll be presenting on outside practice, outside employment, and client diversion issues we've seen in the past. All three of these issues are related to each other, so each section will overlap with the others. The outside practice of law, unless under one of the allowable exceptions, such as representing family members, a charity, or if court-appointed and uncompensated, is a violation of 45 CFR 1604, but can also be criminal if the attorney is working the outside cases during program work hours. This regulatory violation would then become time and attendance fraud. One case we had involved a program's managing attorney and staff attorney. Neither sought permission to engage in the outside practice of law, but they accepted compensated civil cases from non-program clients. They accepted court-appointed guardian ad litem cases, which Part 1604 does not allow. The managing attorney accepted court-appointed divorce cases, included the program's name and address on pleadings for non-program clients, and used program support staff to draft pleadings for private cases. They both assisted private clients during program hours. So how was this outside practice uncovered? Well, the grantee received numerous complaints from clients, and then when they delved deeper into this issue and looked at the attorney's case files, they found that each attorney had over 200 cases that were open. The outcome was that the program received a question cost from LSE for over $20,000 based on time and attendance records. So what are the best practices to prevent a case such as this at your program? Well, the first step is to create a system for receptionists to report large numbers of complaints on a specific attorney. Periodically check court records for attorneys to ensure that they are working program cases, and regularly remind employees they should not be working to assist attorneys with any outside practice. The best way to prevent the outside practice of law is to create a robust outside practice of law policy that initially educates and instructs newly hired attorneys on the restrictions of Part 1604. And this includes mechanisms for periodic reminders to all employees concerning the restrictions, and that the outside practice of law must receive prior written approval by the executive director or whomever he or she designates to approve the requests. In addition to a comprehensive policy, we suggest that programs create an outside practice of law form that is renewed at least annually. The form should include a description of the outside work, the name of the person being assisted, the case number, an estimate of how long the outside practice of law will occur, and an estimate of the total number of hours needed to complete the work. And additionally, a certification that the attorney will inform the appropriate administrator when the outside practice of law has concluded. If the outside practice of law request is by the executive director, then that determination and approval should be made by the program's board of directors. Moving on to outside employment, although it produces many of the same risks that outside practice of law presents, LSE does not have a regulation requiring an outside employment policy, but we strongly encourage grantees to create one. We've had outside employment by employees that have led to cases of employees diverting income-eligible clients to their own outside business for a fee. Employees working that outside employment during grantee hours, amounting to time and attendance fraud, and using the guise of grantee travel to conduct their outside employment, which would amount to travel fraud. We suggest at a minimum that, similarly to the outside practice of law, grantees adopt policies which require the written disclosure and written approval for all outside employment, and create an outside employment form requiring staff to certify that the outside employment will not conflict with program work hours or mission. And for more suggestions and indicators of outside employment, please go to the OIG website and review Fraud Alert 17-02 on outside employment. Next, we're going to talk about averted aid, which will delve deeper into numerous cases we've seen where attorneys and paralegals have used their outside practice or outside employment to divert both over-income clients and income eligible clients to their outside business for personal gain. We've had multiple cases where paralegals or attorneys have used their positions at the grantee to divert both ineligible and eligible clients to their outside paralegal business or outside practice for personal benefit. We've also had cases where a grantee employee has directed a client to their outside translation or process serving business for personal benefit, and the employee has never disclosed their outside employment to the grantee. In some instances, the clients were eligible for free legal services, but were wrongly informed by the employee that the grantee could not handle their case. In other instances, the clients were not eligible for free legal assistance and were diverted by the employee to an associate, accomplice, or themselves in violation of grantee policies. In most cases, the grantee employees took advantage of a lax intake system, and the client was diverted before they were entered into the case management system. Subjects referred for prosecution involving the diversion of clients include grantee paralegals, attorneys, intake staff, and contract attorneys. In each case, the prospective client was diverted during the intake process, including intakes occurring in person, via telephone, and during outreach events. Additional cases also found grantee employees that diverted clients for payment of services such as translation, notary public, and process serving. In these instances, the employees did not notify the grantees of the outside work and potential conflicts of interest. Grantees must adopt sufficient policies to ensure sensitive client information is recorded and secured in the case management system. Otherwise, clients and prospective clients become vulnerable to diversion and fraud. In order to protect against the diversion of clients at your program, grantee policies covering the oversight of the client intake process and the administration of the grantee case management system must adequately protect clients. Also, grantee policies related to the outside practice of law and to outside employment should prohibit the employee from engaging in outside work that may constitute a conflict of interest with the grantee mission of providing legal services to low-income clients. This slide outlines just some of the best practices that are aimed at preventing outside practice, employment, and client diversion. One of the better things to do is to create a strong outside practice and employment policies and forms, and implement a conflict of interest policy. Require prior approval of all outside practice and employment, and periodic internet searches on employees to detect outside work. Check time records against court dockets and travel records, and ensure intake procedures create an audit trail of clients. And please do not share passwords.
Hi, I'm Catherine Silvestri, an investigative counsel with the Office of Inspector General. I will be presenting slides 31 through 36. In the first 3 slides, I will describe examples of investigations into violations of the LSC regulations conducted by our office, and I will also describe best practices for preventing regulatory violations. These are 4 examples of regulatory investigations conducted by our office. In the first example, a grantee employee that was unaware of LSC restrictions regarding political activity inserted a partisan political cartoon into a pamphlet that was produced by the grantee. And the second example involves a few cases that we've investigated. These examples included grantee employees that receive on their work emails an email encouraging them to support a particular political candidate. The emails were sent from other grantee employees. In one case, we found that the email was sent intentionally by the grantee employee. In the second case, we found that the grantee employee did not see the email intentionally. They sent it from an outside email address and simply did not review the contact list before they sent the email to other grantee employees. In the third example, a grantee employee knowingly used grantee time and resources to assist clients going through removal hearings without the knowledge of other grantee employees and without the knowledge of the executive director. In the fourth example, we found that a grantee had a payment practice for a particular PAI contract attorney that resulted in the PAI contract attorney receiving double payment. The attorney received payment one time through hourly invoices and through a second time through a settlement award for the same hours that they've been invoiced for. This case resulted in questioned cost in order to recoup LSC funds. This is a list of best practices aimed at preventing violations of LSC regulations. First, create robust regulatory policies and procedures. Don't just have employees review LSC regulations upon hiring. Create policies and procedures that are aimed at informing staff what the restrictions are and aimed at preventing future violations. Implement training at least annually on the regulations. Some of the examples of regulatory investigations we described in the earlier slide described grantee employees that violated LSC regulations due to being unaware of the restriction. We believe trainings, at least annually, would likely have prevented these issues. Update staff when regulations change or new guidance is released by LSC. Create a practice to inform all grantee employees when regulations are changed or when LSC releases new guidance. Encourage staff to report potential regulation violations or concerns. Grantee policies and trainings should encourage staff to report potential regulatory concerns. If the employee is reporting a violation that may be intentional, ensure the employee is protected with a whistleblower policy. Conduct occasional internet searches for indicators of regulatory violations by employees. If a grantee suspects a violation by an employee, conduct internet searches to determine if indicators exist. In these next 3 slides, I will describe a fraud case derived from a conflict of interest scheme, as well as other case examples with problematic conflicts of interest. I will also describe best practices to prevent these types of issues from happening at your program. Several OIG investigations have included conflicts of interest that were used for the purpose of carrying out a fraud scheme. In this example, the executive director of a subgrantee had her husband register a cleaning business with the state. The executive director did not report to the CFO or the board of directors of the subgrantee that the cleaning business was owned by her husband when she contracted with the business. Each month, the executive director would have the subgrantee pay the business as a way to direct additional money to her family. The cleaning business never actually provided a cleaning service to the subgrantee. An additional example of an investigation that found a conflict of interest used to carry out a fraudulent scheme involved an employee that directed a grantee to contract with a vendor preferred by the employee. In return for influencing the contract, the vendor paid the employee a kickback. The examples provided in the previous slide involved conflicts of interest used to carry out a fraudulent scheme. Other conflicts of interest that have been investigated by the OIG have resulted in questioned cost due to the use of LSC funds to benefit a grantee employee through a conflict. This is a list of best practices for preventing and detecting all problematic conflicts of interest. First, have a conflict of interest policy and a nepotism policy that describes steps that need to be taken when a conflict exists, in both contracting as well as hiring. Also, have a whistleblower policy that protects staff that report problematic conflicts. The next 3 items that are listed are items that should be found in both the conflict of interest and nepotism policies. First, require disclosure of conflicts by employees and members of the board of directors. Second, if a conflict involves the executive director, require disclosure to the board of directors. Third, require employees and/or board members to recuse themselves from decision-making when a conflict exists. And finally, in general, just encourage reporting of known conflicts by regularly reminding staff of the conflict of interest, nepotism, and whistleblower policies.
In the next slides, I will discuss how and when to contact the LSC OIG hotline. Please report your suspicions of any fraud, waste, abuse, or regulatory violations early. Your call can be confidential, and grant assurances protect you from any retaliation for reporting. LSC programs have to promptly report fraud to the OIG. You can easily report your complaint to the OIG by phone, email, fax, or mail. LSC grantees have a duty to report any loss of $200 or more to the LSC OIG. Employees, officers, and directors should report fraud, waste, abuse, and violations of LSC laws or regulations to the OIG as soon as possible. The following are a list of resources provided by the LSC OIG. We are often updating our resources list, so we encourage you to check back often. We encourage LSC and grantee employees to visit the LSC OIG website to review the many resources available. The LSC OIG regularly provides resources on how to best prevent fraud. Those resources include fraud alerts and best practices, the Fraud Corner, guides and presentations such as this, press releases. Please visit our website at www.oig.lsc.gov and look towards our products and investigative results and guidance to help you with any resources dealing with fraud, waste, and abuse prevention.